The question is that the motion be agreed to. The Honourable David Parker.
Thank you, Mr Speaker. I rise to speak in support of the third reading of the limitation bill. I agree with just about everything that the attorney said in his address. Amy Adams says this is so boring. Oh, I'm being boring. Oh, well, Amy Adams' contributions have been riveting tonight, haven't they? I will recount the policy balance that Limitation Acts try to achieve. They try to balance the rights of injured parties to pursue those who have caused them injury through the courts to get redress for the injury that they've suffered through the wrongful actions of the wrongful party. And we want to empower people to do that. We actually want to encourage them to use court processes rather than gangs or fisticuffs because we live in a civil society. But we want to make sure that if they've got rights, they exercise them promptly. And the reason for that is the longer you leave it, the greater the chance of injustice. Memories fade, witnesses die, documents are lost. And in addition to that, there is the need to let the people who, even the wrongdoer, get on with their life eventually and not having the sort of Damocles hanging over their head forever. And how we balance that is to say, well, if you've got rights, you've generally got to exercise them within 6 years. But we make some exceptions. We make an exception if you don't know enough to know that someone's wronged you or who it is that wronged you. So we have an exception that says if you don't know enough within that 6-year period, we'll give you another 3 years. If you've got late knowledge, we'll give you another 3 years. But even that has to come to an end sometime, and so we have a long stop period of 15 years. That's essentially what this bill does. It has a number of exceptions because there are exceptions to be made to those general rules, and the one that the attorney has raised in respect of sexually abused or abused young people is a case in point. You could be abused within your family at a very young age. You could still be under the care and control of those very people that abused you and have no effective way of bringing an action, partly because you're not of contractual age, you don't know how to go to a lawyer, you're probably still living at home, and we don't want those people to lose their rights. They should have some prolonged period to exercise their rights because that's fair, and so we have an exception for them. We have another exception which the attorney agreed to following some overseas precedents, including Canada, where you've got a process injury. You might have asbestosis or some other workplace injury that takes a long time to arise, and there should be an exception in respect of that. The logic around that was slightly confused at one stage as a consequence of ACC, and people thought, well, if it's covered by ACC, we don't need to provide for it under the Limitation Act. But if that logic wasn't quite right, ACC speaks of it in its own voice, and if someone's got an ACC remedy, it's covered by ACC, then they don't have any right to a non-ACC claim because ACC trumps that and says that you don't have any residual contractual or tortious liability, or don't have any residual tortious liability, I should say. But there are cases which may fall outside ACC either because of the current rules under ACC or because ACC rules change in the future. And so it's important that the Limitation Act, Limitation Bill provide for those sort of gradual process injuries in the event that they're not covered by ACC. So that's another exception. The general rule in respect of the limitation period should also apply by analogy to equitable claims. Equitable claims are not claims under statute or under the common law, but arising at equity using the equitable jurisdiction of the courts. But there nonetheless is by analogy, the courts apply what is similar to limitation periods, what are limitation periods by analogy to equitable claims. They apply similar rules to those which apply to common law claims, and there was an amendment made at Select Committee to make sure that carries forward under this legislation. I don't want to give the impression that there will no longer be disputes about whether an action is within time or not. Although this legislation does simplify things somewhat and attempts to minimise the number of those disputes and the injustice that can result from them, we are still going to have disputes as to when people had sufficient knowledge so as to be properly informed of their rights and therefore obliged to bring their cause of action before the courts if they wanted to pursue it. There will be people who say they didn't have enough knowledge when the other party to the claim will say, yes, you did know enough, you've sat on your rights for too long, you've lost your rights, you can no longer sue me. So there will still be disputes as to when people did or did not have sufficient knowledge to trigger the 6-year limitation period or indeed the 3-year late knowledge period. Not all disputes will be avoided, and perhaps speaking as a lawyer, that's a good thing. Amy Adams liked that. She's a lawyer too. Mr. Speaker, the one area where I remain a little disappointed is in respect of this inconsistency that we have for Building Act claims compared with non-Building Act claims. The general rule, the general 15-year long stop period is not being applied to Building Act cases. There, the 10-year long stop period is being left as it currently is. Now, there is a genuine and fair debate as to whether the long stop period should be 10 years or 15 years, and indeed the Law Commission initially recommended a 10-year long stop period for everything. And then they modified their position in their subsequent report and said it should be 15 years, but then we've got this exception introduced for Building Act cases that said it should only be 10 years. And I still am not convinced as to the logic that lies behind that. And I think it is a pity that that wasn't cleared up in this bill, because we were looking at, we had the opportunity to fix it up now. There will of course be pressure from the building industry to keep it at 10 years, because it's in their self-interest to have a shorter period, because it limits their liability. But I'm not convinced that they're right. I think that if we have a 15-year long stop liability period for other breaches of contract or tortious claims, I can't see why it should be different for Building Act claims. I again make the point that this is not of any import in respect of the current leaky home problems that we have in Auckland, because this new bill only applies to wrongs, if you like, or causes of action that accrue from the date after the passage of this bill, rather than things that have already happened before this date. But nonetheless, that principle should have been consistent, in my view, for buildings as well as for other claims. And I make the point that perhaps that the most valuable asset that most people own is their house. If they lose a substantial portion of the value of their house because of a latent defect that they don't know about, that doesn't become apparent for more than 10 years, and it doesn't happen often, but it does happen sometimes, their foundations might fail after a period of time because they weren't appropriately down to hard fill. They, under this legislation, will only have 10 years to pursue their claim. That's the long stop liability under the Building Act. It's unchanged. Whereas if it was a claim in contract, if it was a claim for something less serious, it didn't involve their biggest asset, they would have 15 years to pursue it. And I'm not convinced of the logic. I'm not convinced that the complexity of Building Act cases is so different because of the multiplicity of parties. I agree that's a relevant factor. There is already a built-in protection that it is for the plaintiff to prove their case on the balance of probabilities, and if they didn't, because of the effluxion of time, they weren't able to bring sufficiently good evidence to prove their case, then they lose. So the defence, the other parties to that legislation have that level of protection in any event. Having said all of that, the Labour Party thinks that this is a good bill. Thank the attorney for the consideration that he showed for some of the issues that the Labour Party raised in respect of gradual process injuries, and commend the bill to the House.
Mr. Speaker,